Okay, so I'm looking at the first of the State Department cables published on the 10th of March, 2017, instructing the consulates, which are run by the Department of State, on how to implement the executive order signed on March 6, 2017. And remember, that is the revamped version of the first Muslim ban. So this one only targets 6 countries instead of 7. And the instructions from the Department of State, which means Secretary Rex Tillerson, to the individual consulates are nitty-gritty instructions like, you know, still process non-immigrant visas. That's tourist, student, extraordinary artist, those types of visas. Still process them for non-immigrant visas, conduct the interview in order to determine whether the person is subject to an exemption expressed in the executive order, and if they're not subject to an exemption expressed in the executive order, so they should, in theory, be barred from entering the United States and denied that visa, check to see if they're eligible for a waiver that would exclude them. And then if there's no exemption and there's no waiver, then deny them under INA 212F, which is this really broad statutory provision that says whenever the president finds that the entry of any aliens or any class of aliens into the U.S. would be detrimental to the interests of the United States, he may by proclamation and for such period as he shall deem necessary suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. That is so broad and sweeping. It's incredible. So the non-immigrant visa instructions, and remember that's like tourist visas, student visas, stuff like that, refer directly to 212F. The instructions for handling what are called immigrant visas, and immigrant visas are, an American citizen marries somebody abroad and wants to bring them home with them, and that person gets a green card based on the marriage. That's an immigrant visa. The person is immigrating to the United States. Immigrant visa handling is do the same sort of analysis, do the same sort of case-by-case analysis, hold the actual interview of the immigrant, and if they aren't eligible for any kind of exemption or waiver and the executive order does apply to them, then you deny them under 221G of the Immigration and Nationality Act, which is non-issuance of visas or other documents. No visa or other documentation shall be issued to an alien if, 1, it appears to the consular officer from statements in the application or in the papers submitted therewith that such alien is ineligible to receive a visa or other such document or such other documentation under Section 212. So it loops back to the 212F provision, which says the president by proclamation may set extra conditions on the entry of aliens or certain classes of aliens, or or that, and it's taking 2 steps to get to the same statutory provision, which is this exercise of power by the president. I mean, it actually says suspension of entry or imposition of restrictions by president. I don't have any insight at the moment into the history of the use of this particular provision to be able to tell you. But that is, how consulates are being instructed to handle this at the nitty-gritty level. Hold the interview, go ahead and schedule the interview with the alien, go through everything, figure out are they eligible under the usual rules, and then does the executive order apply to them because of what country they're from? And then if it does apply to them, are there any exemptions or waivers that could let them in anyways? And if there are, then you let them in anyways. And if there aren't, then you deny them under one of these 2 provisions that are actually linked to each other. There is a separate section on diversity visa applicants, but, really the big deal is non-immigrant visas and immigrant visas generally. So I'm just going to, keep my focus on that. The waivers are hardship, not posing a threat to national security. Entry would be in the national interest. I don't know how you prove that your entry would be in the national interest. I think you can show undue hardship. What's the definition of undue? Extreme hardship is defined in case law, because it's the legal standard used in certain types of waivers that we file all the time as immigration practitioners if you do what's called consular processing. An exceptional and extremely unusual hardship is a term of art that's well understood in cancellation of removal proceedings which occur before an immigration judge. But undue hardship, what the hell is that? Where's the case law for that? So here we have, again, some of it is just freaking word choice. It's like, if you guys spend a little bit more time on this, and you hadn't set out from the very beginning, before you even got elected president, Mr. Trump, if you hadn't set out to actually ban Muslims from the United States, you might get away with this, but as it is, we're just going to continue to have more litigation. And there are multiple other cables, probably providing additional instruction, and I'm going to go through them one at a time, but I won't do another video on them unless there's like some, significant nuance that one of them adds that, folks should be made aware of. Okay? And this has been Cedra Vitale, immigration attorney at large. I'm a private practitioner in practice in the Boston area, and one of the nice things to know about immigration lawyers is that we can practice immigration law anywhere in the United States before the relevant agencies, unlike other types of attorneys, because this is federal law practiced before an agency, as opposed to going to a state court, and you have to be a member of the bar in that jurisdiction to go to a state court. So no matter where you live right now, if you're in the United States, you now know an immigration lawyer who is qualified to assist you, or at least advise you as to what you might need assistance about. Okay? So don't be shy about reaching out to immigration lawyers.